it please the court? My name is Brenda Roman, and I represent the appellant, Earl Baring.
Can you pull the microphone a little bit?
Sure.
Thank you.
Is that better?
Yeah, thank you very much.
I'd like to reserve 6 minutes for rebuttal.
6 minutes, okay.
So this case is about a man who was stopped where no crime was reported to law enforcement. And there are two reasons why we're arguing that there was no reasonable suspicion in this case. First, because the nurse's information did not sufficiently allege a crime, and that is controlled by Cooks v. State. Second, because there was no reasonable suspicion to detain Mr. Baring in particular. And today,
Okay, isn't Cooks differentiated very specifically by the fact that that is a hotel that is open to everyone, and here there's, in the middle of the night, this facility had limited number of people that were allowed in?
so in Cooks, the hotel was not open to everyone. It was in the middle of the night, in fact, and there was a clerk behind some plexiglass that was taking IDs, and in fact, the defendant said that he had handed his ID to the clerk, and she said there were no rooms available. And so it was not open to the public, and it was actually the door that was tried was locked. The defendant in that case tried the back door, it was locked.
Okay, would you agree with two statements? Number one, we have to take the evidence in light most favorable to the state because they went below. And I forgot the second part, it's too early in the morning. But here, we also need to take the evidence that was known to the police officer at the time they issued the BOLO.
Yes, that's correct.
Okay. Now, wasn't the police officer, the first police officer that arrived on the scene, didn't he know that the nurse said somebody forced their way into the facility, those were the words that she used, that the facility was only open to people that were visiting, that you saw somebody wandering around, she confronted the person reached into his pocket and or went toward her pocket, and when confronted, the person left the facility.
So
Isn't that reasonable suspicion that that person is trespassing on the facility?
Under those facts, it might be, but that's not exactly the facts in this case.
Okay, tell me where I'm wrong. That's why I
Okay,
wrote it out.
so first of all, like you said, it was open to visitors. They just had to be buzzed in by an employee.
Yeah.
The nurse was one employee of several employees.
Okay, I knew you were going to go there, and that's the question I was going to ask next. At the time they went out looking for this person, did he know that other people could buzz people into the facility?
Absolutely. He
Okay,
said that.
And where in the record does that show? Because it appears to me, looking at it, that at some point he gained that information, but it's not clear to me looking at the record as to when he found that particular information out.
Okay, he did know that information beforehand, and I will get you the record site during rebuttal if that's
Okay, thank you.
what you want. And I would also like to go back, if I can, to the facts as he stated them before. So what happened was the nurse saw this man while he was already in the facility, this unknown man. She didn't know how he got in. There were no signs of the break-in. The officers knew that there were no signs of a break-in, nothing damaged, nothing stolen.
But she did say you had to force the door to get in.
She said that you had to either be buzzed in by an employee or you would have to pull the door hard. She said the magnetic doors were locked, but if you pull hard, you can get in.
Yeah, but taking that, okay, I don't mean to argue with you, but I'm playing this in light most favorable to the state. Combined with the statement that he forced his way in,
But
can't you assume that has to be a pretty hard yank to get into that facility?
But they knew that the nurse didn't know how he got in. She told them she didn't know how he got in.
Okay.
She didn't, so she doesn't know whether he forced his way in or not. Also, the statement about...
Excuse me, counsel, but it is undisputed he didn't belong there.
Well, it's not necessarily. It was never established whether another employee buzzed him in, and certainly the officers didn't know that at the time. It was open to visitors. Visitors were allowed.
I'm asking the converse of that question. There was no evidence that he belonged there. He was a stranger.
That's right, but
And
there was no evidence from the nurse.
And it was 3:20 in the morning when People aren't usually coming to visit Grandma.
Well, that may be so, but maybe your grandma is about to die or something like
Was
that.
there any evidence to that effect?
No, Your Honor, but they only interviewed the one nurse before they went out and stopped Mr. Baring based on the fact that they had seen him earlier.
Okay, if time is critical, do you have to talk to all the witnesses involved before you go out? I mean,
Go ahead.
that's what, hindsight's wonderful. But don't police have to react quickly, especially when they think a crime may have been committed and the person's getting away? And I know we're going to argue about how long it was after, but I'm just saying in general.
If this had been a case of a break-in, they were sure that there was a break-in, that an actual crime had been alleged, and it had just happened or something like that, yes, that makes it much more like a reasonable suspicion case, and that's why we have Terry stops. The Supreme Court has been clear that we have Terry stops so that officers can act when time is of the essence, and that is the reason we have this narrow exception to the warrant requirement.
Okay, let's move on, because you said you wanted to reserve 6 minutes for rebuttal, and I really like to want to talk about this identification issue.
Sure.
Can I just ask one question? The officer made a statement, the second officer, the officer that stopped the defendant here, that I'm not sure if there was anybody else on the street. Something along those lines. Taking that in the light most favorable to the state, does that mean, can we assume that there was nobody else on the street? There were very few people on the street? I mean, what is a reasonable assumption from that statement?
Well, you can probably assume there were a few people on the street because it was 3:20 in the morning, but we don't even know if that was the street where the unknown man might have gone. There's no information as to where the unknown man went in the 50 minutes before the nurse called law enforcement, or even if he was on foot or in a car. So honing in on that one particular location, the only reason to do that is because the officer saw this man earlier who fit the vague description of having a blue jean jacket, blue jeans.
Okay, and admittedly, the question about each saw my eyes and turned away is somewhat vague, but what can we draw from that statement?
From looking away and not making eye contact, there's nothing, that's no inference of a crime, and there are cases that are very clear about that, and I think I cited one in my brief.
Was the description here vague? I mean, it seemed like there were a number of factors. They described race, they described gender, they described what he was wearing up top, what he was wearing below, pants, wise, height. So it seems like you have at least 5 factors there that the first officer saw somebody, relatively soon after the call or after the incident took place, and then the second officer went and found that guy. Is the rule that you want us to adopt the holding here that even that in the face of a 5-factor match that's still not enough?
I don't think we should have any bright line rule as to how many factors we need. I think this court has been clear in Sanders where the rule was if many people can match the description, then it's too vague. And also in Cobb that you have to take into consideration the location you're interested in. Is this a very rural, sparse location? In Cobb, it was a location where apparently very few African Americans lived.
So it kind of brings the time of day and the fact that 2 officers said this is the only guy on the street at night that met the description back into play.
Well, so one officer, they stopped Mr. Baring in particular because one officer had seen him earlier on this road, maybe less than a mile away from the facility. So
I just want to point out you're under 6 minutes.
Yeah, that's okay. So the vague description is all they have is a black male, blue jean jacket, blue jeans tall, and they don't know whether he was on foot, whether he was in a car. He could be in an indeterminate radius. He could be in a building. He could be on a road, in a car. We don't know. The officer just sort of tried to cram in to hear something he had seen earlier and into the description that he received, and that's why Mr. Varian was stopped. And if there are no further questions right now, I'm going to reserve the rest of my time for rebuttal.
May it please the court, counsel. Good afternoon. My name is Michael Schaub on behalf of the state of Florida. Now, two issues the appellant raised. First issue, whether or not there was reasonable suspicion from the nurse's tip of a crime. And the trial court on page 107 actually made the finding that there was reasonable suspicion of criminal activity. And to support that finding, they made several factual findings, and these can be found on pages 106 and 107. They made the factual finding that a person had forced his way into a lockdown facility in the early morning hours. That facility was closed. You had to be buzzed in by an employee to enter that facility. And furthermore, that no one indicated they buzzed this person in. And also that was a high crime area. Now, all of these factual findings support that there was reasonable suspicion
Wait a
of
second.
crime.
It goes both ways, that no one buzzed this person in. Did he know that no one else had buzzed this person in at the time he issued the bolo?
He checked with the nurse. Nurse said, I didn't buzz him in, and that's the information he had. He didn't check with any other employees.
Okay, so I just wanted to make sure.
Yes, so that's a correct statement. And the facts in the case, in the testimony evidence, are competent and substantial to support this factual finding and to support the ultimate finding. You had a person out, or you had officers testify that they responded to a burglary call at 4:10 in the morning. They went to this nursing and rehab facility that wasn't open to the public at that time.
Okay, you brought up the time the police responded to the call, and I'm going to work into the description because I'm really concerned about this description issue. The timeline I have is the nurse made contact with this individual at 3:10. The police did not receive the call till 4:10. It is the person was not, in fact, stopped till at least 4:30. That's almost an hour and a half after the alleged contact occurred. Isn't that problematic? A lot of our cases that talk about, an escape route, you have information about which way the person probably went. It's close to the time the crime occurred. You have specific information about how many people are on the street or around that time. Do you have any of that here?
And you're talking about the description issue, correct?
Yeah.
Okay.
I
Away
kind
from
of
the reasonable
prefaced
suspicion
in.
of
I
the
want to
crime.
get to the
Okay.
description thing.
Now, as to the description issue, I'd argue that the 15 minutes actually helps the description because he's 2.5 miles away walking down, so it's reasonable to infer
So
that.
4 hours would be 7 hours?
Excuse me,
7
I'm sorry.
miles? So if it was 4 hours after the crime, 7 miles, that would fit it? Because I would think somebody might walk 7 miles
Well,
in
then
4 hours.
I'm sorry. But then you had the other officer who said he saw an individual matching that exact description approximately a mile away about 20 minutes after the crime had occurred. And he saw that individual 30 to 40 minutes.
And
when
why
he
was
got
that
the call.
person suspicious?
He wasn't suspicious. The officer says that basically he's not looking at him. So he doesn't think much of it, but it makes him like it gives him enough to notice the guy, right? And he's wearing a dark denim jacket, jeans, and he matches the exact description of the nurse.
Okay, you say he matches the exact description of the nurse. What is distinctive about the description that the nurse gave?
It's a dark denim jacket, jeans, he's black male, and 6 feet in height. So it's a pretty specific description, especially considering the fact that there's no one out at that time Officer Cabrera makes a stop. He testifies. He doesn't remember anybody else being out. So it's reasonable to think that given the circumstances that he matches that exact description, he's in a time and a location where there was no one else out, much less a person matching that description to stop this person, especially given
Is
Officer
there any
Paul's further
testimony in
say.
this record that we could assume that would be and I'm going to use the term escape route, that's the escape route somebody would use?
No, there's no testimony to that.
Okay. And who does that weigh against? I mean, doesn't the state have the burden of proof here?
Yes, but I think you have to have a reasonable inference, or you have to judge about the reasonable inferences that the officers made at that time. And the officers had the description of an individual that matches the nurse's description that was less than a mile out. And it's reasonable for that Officer Paul to direct Officer Cabrera in that individual's direction, that he saw an individual that he didn't remember anybody else matching that description walking down this road.
Somebody's
less than a
walking
mile away.
awful slow. If in 1 hour after the incident, they only go a mile, right? I mean, trying to, kind of parse this out.
Well, it's not supported by record how fast a person can go. I know I can't walk that far in an hour.
Well, I walk on a treadmill sometimes.
Yes, sir.
And not walking too fast, I'll walk about 4 miles an hour. So 1 mile, in 1 hour doesn't seem like a lot of ground that can be covered, especially if I'm trying to get away from a place where I've committed a crime.
Yes, sir.
You think it's important that the second officer found the defendant walking along the same road in which the first officer saw him? If he would have just found some other random person matching this description in some other random place, would that make a difference?
I think it is important that this officer found, or the first officer's description, that he found an individual matching this description a mile away, because that then gives Officer Cabrera an indication about where to go. And that's why he goes in this place, and that's why he's directed in this vicinity. And he sees a person matching that exact description that not only the nurse, but Officer Paul gave, walking away from the facility, getting further and further away. So yes, I do think it's important. And so I think for the reasonable suspicion of description, I think the description is sufficient given the factors that the nurse gave, given the fact that he's in a time and a place that no one else was around, much less a person matching that description. And then, so all these things I think support the reasonable suspicion to detain the defendant. And as far as reasonable suspicion of a crime, the only one thing I wanted to point out from the Cooks case, that the appellant said that basically Cooks, there was testimony about the plexiglass, that the end was plexiglass, and the clerk had to let that person in. But that's actually the appellant's testimony in the court, or to the court, saying that when he testified during the hearing. And actually the appellant said that wasn't the inn he was at. He was at the roadway inn. The incident happened at a place called the Blue Angel Inn. So you had no indication that inn that night, how it was set up. And furthermore, the officers didn't know that at the time of the stop. And given the factors and the facts and circumstances, I also believe that there was reasonable suspicion that crime occurred to support the
What is one of our cases that have upheld a suppression, upheld the denial of the suppression that you would think would be the closest to what we have here today?
To deny.
It's a moot court question, but I've read all these cases. What do you think is your best case?
I cited State v. Webb. In State v. Webb, it's basically the case where officers get a description of an individual during an officer meeting. And it was basically that this person was committing robberies about 2 days prior. The officers get a specific height, a specific weight, hair, and I believe it was blonde ponytail, and then white male. The officers go out 6 hours later and find a person in the vicinity of 2 and 2.5 miles away from the vicinity of the robberies. And keep
So
in
there was
mind,
less a description than here because they didn't have clothes.
they didn't have, well, you could
But
argue that they didn't
but
have
they had
hair.
weight and they had hair.
But in this case, they did have the clothes. And keep in mind, these robberies happened about days earlier. And the officers actually find the guy when they get the call about 6 hours later. And he's in the geographical vicinity of our defendant, 2 and 2.5 miles away from the incident where the robberies took place. Now, I think furthermore, when the officers stop the guy, they bring him back to the show-up. And like in our case, he just doesn't match, or they didn't find that he was the one after doing the lineup. So they didn't charge him with a robbery, but they did charge him with carrying the concealed weapon.
In Webb, wasn't there some kind of suspicious behavior as well, I thought?
I don't believe so. I don't recall, though. I think he was
I
just
should go back and look. But
Yeah. But that's the case. And this case is so factually, driven that it's hard to kind of find a similar factual case.
I guess my concern is, would you at least agree that a blue jacket and blue jeans is not a very distinctive outfit?
Not given the circumstance, or not given the totality of circumstances, I think it's a pretty specific description. It's a dark denim jacket and dark blue jeans. That's a specific clothing description to me, at least.
Okay, in certain neighborhoods, I think you'd see that a lot.
And and given the time of day and where they were, then the officer's testimony that he didn't see anyone out there, much less a person matching the description. So I think
No, I understand we have to get the totality of the circumstances, but I'm kind of breaking down the individual things. I don't find blue jeans and a blue jacket to be very distinctive. Okay.
Okay. And if there is any further questions, I'd ask this court to affirm the lower court's ruling. Thank you.
Thank you.
Okay. First, I'd like to go ahead and, while it's fresh in our minds, to address State v. Webb. Like you said, there was weight, there was height. He was, I think, a thin build, white male, ponytail, blonde hair ponytail. He had robbed 2 specific drugstores that were named in the bolo, and he was found in the vicinity of those stores. And so, not only do we have a more specific description, but we also have clearly a crime has taken place. And I think even if you don't agree with us about whether or not this description is good enough, considering that we don't even know where the unknown man went, I think you still have to agree that this case is controlled by Cooks because we just don't have a crime here. I've looked in the record. There's never a clear question to the officers as to, did you know how many employees were at the facility before you went out and stopped Mr. Bering? I don't see that question. I don't know that answer. But it must be clear to them that there's more than one employee at the facility.
Yeah, but it wasn't clear to me reading the record that if somebody tells me I didn't buzz them in, it seems to me that the fair assumption is that I am the person that buzzes people in. And unless I have some other information that other people can buzz people in.
One nurse at a
I'm taking
nursing
this in light
facility?
most favorable to the state, which we're required to do.
Right.
And I'm not sure that the police officer had information at that point that there were other people that had the authority to buzz people in at the time of the crime, of the alleged crime.
Well, on cross-examination, he was asked, this facility wasn't exactly locked down at the time, right? And he said, well, no, but an employee has to buzz someone in. So I think he did know about the buzzing in issue.
I agree, he knew by the time of the trial, but it's not clear to me. I mean, his information as to what he had at the time of the bolo was, this person forced his way in, I didn't buzz him in. At that point, it's not clear to me that he had information that other people could have buzzed this person in.
Okay, well, he did know that if you pull hard on the magnetic doors, you can open them.
No, I understand that. I just...
And, I mean, I guess we're going to go in circles on this if we keep going, but...
I agree with that. Go ahead.
So what I would also like to say is to go back to your very first factual conceptualization also. The idea of him leaving upon being confronted is also not what the nurse said. She said that she saw him wander around for a few minutes and then leave. She said he had his hands in his pockets, hands plural, and she speculated that maybe he might have a weapon. Well, just like in RE that I cited in my brief, where we have citizens saying, well, they're passing things back and forth, that's a drug deal. That's not enough to believe that the unknown man had a weapon in this case. And it's certainly not. The officer is very clear that he did not ask the nurse whether or not she spoke to the man before they went out and detained Mr. Bering. So there's no record of a confrontation or anything like that. We have a man who wandered around for a few minutes and then left. If there are no further questions, thank you.
Well, thank you both for a very good oral argument. Seeing no further cases in front of the court will stand in recess.